Well, welcome everybody to this session on the Trans-Pacific Partnership. I'm Andrew Jackson. I'm a policy advisor with the Broadbent Institute. Just before introducing our panel, I'll just say a few words about the Trans-Pacific Economic Partnership Agreement. Just before getting into that, I just thought I'd mention it's a common saying amongst trade negotiators that trade negotiations are a bit like riding a bicycle, which they mean in the sense that it's important to keep momentum for further progressive liberalization through trade and investment agreements. But of course, it's an absurd metaphor when you think about it, because people who ride bicycles stop all the time and try and figure out where they're going, where they come from, can look at a map, reflect on what they're doing. And that's exactly what we're trying to do here, is to throw some critical light on the TPP. It's been concluded by 12 countries, including the US, Canada, Japan. It's now in the stage of ratification. So the government of Canada has decided to hold hearings on the TPP, parliamentary committee hearings. They have signed it, but it still has to be passed by the House of Commons. The government has formally taken the position that they're listening to Canadians rather than taking a position on an agreement signed by the Harper government. There will be a vote in the US Congress probably later this year, probably by the lame duck Congress. So what are the key issues at play here? Just to flag them very briefly, there's the investor-state dispute settlement mechanism, which allows investors to take governments to court for adverse regulatory decisions that they feel impinges their profits. The TPP extends what's in NAFTA to additional countries. There's detailed provisions there. There's also detailed new rules covering intellectual property, copyright, patent rights for drugs, a major extension of what's in existing investment agreements. There's new provisions regarding the trade in goods. In the case of Canada, the addition of Japan to the TPP and greater exposure to trade with China by TPP signatory countries raises major issues. And finally, there's the whole issue of labor and environmental rights. There's claims that these are being protected in the agreement itself, and that's certainly a controversial area. So those are the four areas we're going to concentrate on in the discussion today. Our speakers in the order they'll be speaking are Michael Geist, to my left, who's a law professor at the University of Ottawa, where he holds the Canada Research Chair in Internet and E-commerce law. Dr. Geist has been a leading critic of the TPP, particularly as it relates to privacy and intellectual property rights. I'll just introduce the whole panel. Ianik Marcil is a leading independent economist in Quebec who specializes in technological innovation, social transformation, and economic justice. He's a regular commentator on economic affairs and writes a column for Le Journal de Montreal. Welcome. Pia Eberhardt joins us from Germany. She's a researcher and a campaigner with the Corporate Europe Observatory on International Trade and Investment. The Corporate Europe Observatory works to expose and challenge privileged access and influence enjoyed by corporations. Pia will be mainly speaking to the EU experience and lessons on that for Canada, and presumably bring a European perspective on where the trade liberalization process is going internationally. And last but not least, my former colleague at the Canadian Labour Congress, Angella MacEwen, CLC economist, working very closely on the trade file. So I'll turn it over to you, Michael.
Great. Well, thanks very much, and thanks for the invitation to come and speak. So earlier this year, I started what I thought would be a relatively short series on my website called The Trouble with the TPP. And the idea was to post on a daily basis, unpacking some of the issues, primarily around the digital issues, copyright, intellectual property, privacy, and the like. And I thought that I would go for about a month, start at the beginning of the year and stop when they signed the agreement, which was well known to be the beginning of February in New Zealand. As I unpacked the agreement more and more, it turned out there was more and more to write about. And so it ended up becoming a 2.5-month series. There are 50 posts on my blog, and it's about 45,000 words when you add it all up. And I think will end up becoming part of a start of a book out later this year. And what I learned from that process was that there is so much more once you dig behind it. I think what we find is that a lot of the people who talk about the TPP, frankly, a lot of the people who cheerlead on the TPP have never bothered to actually read the TPP. Most of what they have done is simply cheerlead the idea of trade and trade with these partners. But once you take a closer look at what the deal actually entails, I think there's real cause for concern. Now, I don't have a lot of time, so I'll just try to focus on a few things. And I'd even start by noting that the price of entry for Canada was significant. Some of the changes that we've made on our copyright rules, some of the changes we've made in terms of the power that our customs officials have and the border measures that we have was part of the conditions that were set for Canada to even be part of the negotiations. We were late to the negotiations. There was opposition for Canada even joining from the United States, from some people in the United States and others. And so we made significant changes to our laws and our regulations even before we started. And I'd argue that that's really part of the price of the TPP. Now, within the agreement, there is an awful lot to talk about. There's the intellectual property rules around things like copyright. For example, we're required to extend the term of copyright protection from life of the author plus 50 years to now life plus 70. That's often known as the Walt Disney extension from the United States because it kept Mickey out of the public domain for an additional 20 years. The New Zealand government took a look at that issue and they've estimated that it will cost their country alone 55 million New Zealand dollars a year. That's for an economy and 1/9 the size of Canada. And so the costs there are significant. From the healthcare and patent perspective, it locks in some of the extensions that we agreed to as part of the European trade agreement. It actually even sets rules for a national pharmacare program. If we were to have one, it has regulations on things like medical devices. So it touches on those sorts of issues. It touches on biologics, next generation pharmaceuticals, that in many respects, we even ourselves don't really know what an optimal term of protection is. There have been studies that argue that there is no need for additional protection, that the market itself has enough incentives to experiment with biologics, that in fact it takes so long to create the generic version of biologics known as biosimilars that effectively you already have the necessary protection. In fact, countries in the TPP have all sorts of different terms, and in the United States at the moment, it's 12 years, but the Obama administration now would like to roll it back to 7 because they've recognized the cost that it's having on their healthcare system. This now locks us in, and locking us into a term, in this case it's 8 years or 5 plus 3, depending on how you interpret the agreement, means that as we learn more about what this market, how this market evolves, and what a truly optimal term of protection is, we won't have the alternative or the choice to make that choice because we're locked in through the TPP. In other IP issues include things like criminalizing trade secrets, which is an unprecedented step for many countries, including our own. On the digital rights front, you find that there are all sorts of concerns and different issues that are raised. And actually, just even before I get to that, I should also note the cultural concerns here. Many of you will know that having a cultural exception has long been one of the core issues that positions that Canada has taken within trade agreements. In this particular agreement, you don't get that. And in fact, there is an exception for culture, but then there are exceptions to the exception within the cultural process. And so, for example, those that have argued that we ought to consider ways in which some of the new over-the-top video services like Netflix pay into the system will actually be excluded or precluded from even considering those kinds of regulations under the TPP. And then you get a whole series of other sort of digital rights issues from a privacy perspective. And I should note that these are the kinds of things when we're talking about privacy and the like that some have suggested this makes it sort of a new agreement, that one that's positive for many because it finally addresses some of these internet issues. But once you scratch below the surface and you actually look at the terms, you find it's got privacy rules that are incredibly inferior compared to the kinds of things that we have here in Canada right now. It's got restrictions on things like data transfer and data localization, the sorts of rules that many countries are entertaining right now when they start thinking about the prospect of how do we protect ourselves from some of the surveillance activities that take place. So there's a lot there, and hopefully through the discussion we can unpack some of these a bit more and then talk as well about what happens if we do decide to move forward, because it's not the end of the story to say, okay, Canada is going to ratify. In fact, that's when some things get particularly difficult, as the United States has reserved for itself the right to decide how Canada itself will ultimately implement this agreement if we decide to do so.
Thank you. Ianik.
Thank you. The motivation between free trade agreements and the very concept of free trade, as thought out by the 19th and the 18th and 19th century liberal thinkers, was really to liberalize the economic life from political arbitrariness. Free trade agreements such as what we're talking about, the TPP, but also the free trade with the European Union, as Michael said, are now a second generation trade agreements, which go against this principle of liberalizing economic life from political arbitrariness. For instance, this treaty wasn't politically discussed in Canada or anywhere else. Unlike the 1988 federal election, the election was triggered by Mulroney, exactly on the free trade agreement with the United States. There were political discussions, there were public discussions, and in Quebec, for instance, back then, we had a minister of the economy, a finance minister, Bernard Landry, who became premier back then, later, and who published a book right then to explain the free trade agreement with the U.S. In the case of the second generation trade agreements, this discussion has been more or less absent from the public sphere and from political life. At the time when last year's federal election was called, 75% of Canadians had never heard about the Trans-Pacific Partnership. 3/4 of Canadians didn't even know what TPP stood for. What worries me is, on the one hand, this absence of political debate or even media discussions, and on the other hand, the fact that these second-generation treaties are not really free trade agreements. 90 to 95% of the goods transacted or sold by those countries are already exempt from customs duties, or they have very low customs duties through bilateral agreements and the World Trade Organization agreements, for instance. So we're not talking about free trade here, but as Michael said so clearly, we're talking about rules, legislative and political decisions that are being discussed, and environmental standards, intellectual property standards that come with these treaties. And basically, we're watering down the sovereign power of the state to legislate and to govern economic, intellectual, and research activities. So we're not talking about free trade agreements. These are basically political treaties that are not described in those terms. They're not the result of political deliberations. Meanwhile, they're called trade agreements. I was talking about classic liberal thinkers. Adam Smith was a promoter of economic liberty, right? And who was also against political arbitrariness. He was very wary of trade liberalization agreements that are basically mercantilist. He talked about a nation of shopkeepers that he was very, very wary of, because as far as he was concerned, Adam Smith, that is the promoter of classical liberalism, the state would have lost all control on development, on technological, cultural development and education, by reducing itself to purely mercantilist principles. To my mind, of course, it's easy to attribute things to the dead, but to me, Adam Smith would have opposed these second-generation agreements. These are not trade agreements. These are not free trade agreements on goods and services. We're talking here about agreements that, at the end of the day, are basically an abdication of political sovereignty. That's it. That's it for me.
hello. I thought it might be interesting to contribute to this debate with telling you a little bit about what's going on in Europe at the moment, because what we are seeing in Europe, or have seen in the last 3 years, is an unprecedented, broad and growing movement against a number of free trade agreements, not the TPP, because Europe is not part of that, but similar trade agreements, in particular the planned EU-US TTIP, but also the EU-Canada CETA agreement. So what is going on is that in Europe, over 3 million people have signed a petition against both TTIP and CETA. They want an end to the TTIP negotiations and CETA not to be ratified. We have hundreds of municipalities across the EU that have declared themselves CETA and TTIP free. Many of them are under left or social democratic governments, but not all of them. The city where I come from, Cologne, a city with 1 million inhabitants, in that city, which is also TTIP and CETA free now, we have the resolution was approved by nearly all parties, including the Conservative Party. And we have a number of countries in Europe, Germany, Austria, the UK, and the Netherlands, where we have coalitions of small and medium enterprises against TTIP and CETA, so SMEs against TTIP. So this already gives you an idea of the breadth of the opposition, which has gone far beyond the usual suspects, the environmentalist groups, and is creeping further into conservative areas of society. And that, I think, has to do with the nature of these agreements, and some of the issues have already been mentioned. They go to the heart of many things that are dear to the middle class. For example, protection standards when they come to food safety, and they go to the heart of democracy and the way our democracy will work in the future. There are many concerns in this movement against today's free trade agreements, but I would say at the heart of the debate is a controversy over ISDS, so the investor-state dispute settlement clauses. And I just wanted to share with you some of the concerns, because they equally apply to what's been negotiated in the TPP. So one concern is that under these provisions, foreign investors get extreme privileges, much greater rights than anyone in our societies have under national constitutions, also European law, whether it is you as citizens, whether it is national businesses, labor communities of any sort. The second concern is that investors have used these provisions and will continue to use these provisions to attack everything they dislike, whether it is a law passed by Parliament to protect public health, or an executive act to protect the environment, and even court rulings. The third concern is that ISDS provisions can be used to get a lot of taxpayer money in compensation, sometimes billions of dollars, and money that would never, ever be handed to these corporations under our national legal systems, which has to do with the greater rights that they get under the investment chapters. Another concern is the regulatory chill effect, so the fact that these enormous privileges can be used to intimidate policymakers, to make them not implement certain laws and regulations that would be needed, for example, to fight things like climate change. And the last concern is the deeply anti-democratic character of ISDS, because when it makes it more difficult for policymakers to regulate in the public interest out of fear of being sued, that is a problem under democracy. But it's also a problem that you really change the balance of power in society by giving the already very powerful group of foreign investors. When you have the capacity to go abroad to invest, you're usually not part of the economic weak parts of society. So to give these groups extra rights changes the balance of power in our societies by just giving them more power that they already have. So these are some of the concerns that are raised. And again, they are not just raised by the usual suspects. We have our Judges Association in Germany, but also the European Association of Judges, coming out very strongly against the provisions of ISDS in the CETA and proposed for TTIP. They say whatever is proposed is not an independent system, and it's not the way to fix problems in our courts. Giving special rights to one group in society cannot be the way to address legal problems if they exist. So this is to share with you what's going on in Europe at the moment. And maybe, because I was also asked what lessons do we have for people in Canada? And first of all, you had so many lessons for us because Canada is the most sued developed country in the world under ISDS provisions, so we could learn a lot from the cases against Canada. But maybe the lessons that I draw from the movement in Europe is that these agreements are not about trade. They're enormous corporate power grabs. They're power grabs by the executive and trade lawyers over other parts in our democracy, such as parliaments. They have a lot to do with our democracy, and there's a lot to defend against these agreements. And this is what will happen in Europe in the months to come. There will be a strong movement which will hopefully prevent that CETA gets ratified, and will hopefully make the TTIP negotiations so complicated that we never see a final deal. And I hope that we can continue to count also on your support, the support of the Canadian trade union movement, for example, in this fight against these trade agreements. Thank you.
Over to you, Angela.
So, everyone has already pointed out that these aren't trade deals. So why are we doing it? Why are we entering into these negotiations? These trade and investment deals are sold on the basis that they're good for the economy, that there will be winners and losers, but there's more to gain than there is to be lost, and that the benefits from trade will be shared widely. This is what we're told. This is what the cheerleaders say. And there are economists who will use models to show us that, yes, this is what happens. But we know that models are simplifications, and there are assumptions that must be made in these models. So when we examine the assumptions that are made by the cheerleaders, it's very telling. And there are three common assumptions that are made when you're assessing trade deals in the standard model. The first is that by assumption, there is full employment. That the sectors of the economy that lose out from trade, those workers will find new jobs in the sectors of the economy that win from trade. That is, by assumption, we assume that there is no effect on employment. The second one is that the distribution of income within the economies is either constant or increasing. And then the third assumption is that there are constant trade balances. So that any increase in imports, for example, with South Korea, that any increase in imports of automobiles or cheaper electronic goods will be matched dollar for dollar by an increase of exports, perhaps canola or beef. And that, again, those benefits will be shared widely. So even when you use this model to analyze the Trans-Pacific Partnership, it shows very modest benefits. 10 years out, it projects that Canada's GDP will be 0.5 percentage points larger than without the TPP. But we know that those assumptions are wrong. We know empirically that that is false. What happens in the wake of trade deals, we saw with NAFTA, that it hollowed out manufacturing in Canada and the United States. Workers in Oshawa and Detroit were now competing with workers in Mexico. And those Mexican workers didn't have the same rights and protections or wages that workers in Canada had. So what we do see is we see this weakened bargaining power for workers. We see lower wages and working conditions. We see job losses. And we don't have a magic wand that turns auto workers into computer programmers. So some other economists thought, well, what if we relax these assumptions? What if we assume that employment does change? What if we allow income distribution to change in the model? And what if we allow the amount of exports and imports to be different? What would we see then? And Geronimo Capaldo at Tufts University did this for the TPP. And what his group found was that for some TPP countries, there is a modest positive benefit for GDP growth, but that for workers in each and every TPP country, they lose out. Income inequality increases in each and every TPP country. Workers lose. And this supports empirically what we see happen in trade deals. We see that they're designed for corporations to benefit, and they're not designed for workers. And on top of that, in the Trans-Pacific Partnership, we have an international labor mobility chapter. And this opens up all kinds of agreements that we've had. We allow workers from Vietnam to come to Canada, and Canadian workers can go and work in Vietnam. And so we had this whole debate in Canada around the temporary foreign worker program. And the Conservatives lost that debate. We said, if a worker is good enough to work in Canada, they're good enough to be here permanently. We don't want companies in Canada to rely on this rotational workforce of more vulnerable workers, because if you're here temporarily, you don't have the same access to protections that you would if you were coming here permanently. So Canada gives up in the TPP labor mobility chapter. We give up the right to implement a needs test, to say, you know what, we don't need any more fishermen. We don't need any more computer programmers. So if you're going to come to Canada, we want you to come. If you're going to rely on this really vulnerable temporary form of labor, you have to really show us that you need it. Well, we've given up the right to implement that. We've given up the right to demand that a firm advertise in Canada first. We've given up the right to set any numerical limit by industry or by country coming in. So what you can think of happening is that there will be more of the RBC type arrangements where workers are training their replacements, and these workers have fewer protections available to them.
Thank you. Michael, I'm kind of somewhat puzzled about where the TPP came from originally. My suspicion is, in terms of the provisions that you're particularly expert in, that there's been a very strong corporate lobby in the US to lock in a sort of technological innovation advantage by American companies. And then in your remarks, you sort of touched on the special role of the US vis-a-vis ratification. So can you kind of connect some dots here in terms of the Canada-US relationship?
Sure. Actually, it's worth noting that the TPP didn't even start with the United States at all. It started with a very small agreement involving New Zealand and a few Pacific countries. And gradually, there was a desire to open that up, first to the United States, and then, as many of you will know, Canada, Mexico, and Japan came along a bit later. One of the, and I think you're quite right to point to the very close alignment between the US negotiators, the USTR, and the technology community, or even more the intellectual property community in the United States. One of the things that's striking about how these negotiations take place is that there is strong secrecy associated with the text. Many of you will know that as well. There were a few leaks through WikiLeaks, but for the most part, the text isn't made available. But what's interesting is that while the US demands that secrecy, they have active groups from the industry lobbies that are able, under non-disclosure agreements, to gain access to the text. So they kind of have their cake and eat it too, where they require everybody else to maintain secrecy, but they provide access to their own companies. In fact, if you take a look at some of the people who've been critical of the TPP here in our own country, they include people like Jim Balsillie, the co-founder of Research in Motion, the BlackBerry, Toby Lutke, the CEO of Shopify here in Ottawa. These are sort of some of the largest and most successful tech companies that we've seen over the last couple decades in Canada. And one of their core concerns has been that they weren't consulted, and that in fact this deal is structured in a manner to clearly advantage US entities, oftentimes at the expense of Canada. And so there's not a whole lot there. I think the point that when you take a look at the economics behind it, what's in it for Canada, there's not a whole lot. The study suggests that it's quite low. We already have trade agreements with roughly half of the TPP. So the incremental gains that we get are pretty small when compared to some of the costs, both that we agreed to even just to enter into the negotiations, as I mentioned, but even more as part of the agreement itself. And then just one quick last point. when you talk to Canadian negotiators, one of the things that they try they make the case that they like to have language in Canadian law that is slightly different from the language within the TPP. And they argue that that provides some amount of flexibility for interpreting what the agreement itself requires. The problem, and I hinted at it in my opening remarks, is that the US maintains that it has the right of certification. Certification not for its own implementation of the agreement, but for the implementation of all other countries. And so what happens is, as a country moves forward with a ratification or implementation process, the US conducts its own process of reviewing what that other country has done. And they solicit comments from the corporate sector and from other entities to review whether or not they believe that, let's say, Canada has been compliant with what the US expects that Canada is required to do under the TPP. If you don't meet the standard, the US maintains that it won't provide certification and the agreement won't take effect. They're able to do that because the agreement cannot take effect unless the United States becomes part of it. And so they maintain that they won't become part of it until they've had the chance to certify the other countries and ensure that they meet their own standards. And if we look at the experience elsewhere, the US-Australia free trade agreement, for example, Australia went forward with their own implementation. This is just over 10 years ago. They provided it to the United States. The US said, we can't certify this. Go back and make changes. And so, in a sense, we haven't just signed on to all of these changes. We've even, in effect, signed on to the US deciding whether or not our own implementation is up to snuff.
That's interesting. Ianik, we have a new federal government and promised to rebuild the middle class, put emphasis on a jobs agenda. I guess there was a lot of talk in the budget about building an innovation agenda moving forward, green jobs, job creation from protecting the environment. Not a lot of flesh on those bones yet, but do you see the TPP as standing in the way of those sort of economic development policies, job creation policies that we should be looking at?
Absolument, c'est...
Absolutely. It's clear to me, first of all, the Prime Minister announced that Canada would be ratifying the Trans-Pacific Partnership. He didn't elaborate, but it is clear, as everybody has said for a while now, that this treaty will really throw a spanner in the works in terms of any economic, technological development and protection of the environment, and that whole mix that we've been trying to achieve for years now. But especially this Trans-Pacific Partnership will be affecting the small and medium-sized high-tech businesses that are Canada's strength, that count a lot for the strength of the Canadian economy, and we talked about the impact on the workers who will be hit hard, as well as consumers. And Pierre talked about what they call in English the ISDS, that is the conflict settlement mechanisms, and that is at the heart of these second-generation treaties. They're there just to protect the big multinationals, as you showed so well. And they will weaken medium-sized businesses. Middle-sized businesses, which are into high-tech and export a lot, will be affected a lot because they are the heart of Canada's economic future, and that applies to the other signatory countries as well. Those businesses are the engines of the new economic development policies that the Trudeau government are counting on, and they will be hard hit in their own development and in their own export markets. To me, the best ally, we were talking a while ago about the reconstruction of the left with Mr. Bira. The best ally of the left and the workers and unions is medium-sized tech companies that are innovative, who could really form a common front with unions and social movements to stop the ratification of this TPP and help develop these new economic policies that Mr. Trudeau has promised.
I guess it's more on the Canada-EU agreement than on TPP, but I mean, obviously there's been a lot of concern in Europe. Maybe it goes back to the multilateral agreement on investment, for those of us who remember that got derailed. But around the investor-state dispute mechanism, which I understand is not part of trade and investment liberalization in the EU. I mean, if companies feel they've been, well, if they're opposed to regulations and so on, they have the right, I assume, to bring cases before the courts of the country in which they're operating, but there's no special circuit for investors to question domestic law. But is it fair to say, I guess the question is, are the provisions in the Canada-EU agreement around trade and services some of these areas that you would find of concern? Or is it just the investor-state clause
No,
that there's so much attention is being given to that stands? In other words, should we support these kind of agreements if we fix this one aspect of it, or is there much more structurally wrong with them?
No, I really didn't mean to suggest that ISDS is the only problem in the CETA agreement. I guess Michael could talk for a long time about the problematic IP provisions in CETA, which will, for example, drive up drug prices in Canada. In Europe, there's a strong concern about the services chapter and what it will mean for public services, which are not adequately protected. It will be very difficult, for example, if a city that maybe in the 90s decided to privatize its water and would like to take it back into public hands because prices have gone up, or the companies didn't invest in the water system as they had promised. These kind of reversals will be very, very difficult with CETA, or at least very expensive. There are concerns that some provisions in the CETA will lead to more GMO imports into Europe, which is a big issue. Europe, in many countries, is still largely free of GMO food. Financial services, big concern. How on earth will CETA's chapter on financial services allow the stricter regulations that we need for the banking sector if we want to prevent the next economic crisis? So the list goes on and on and on.
So we're likely to see a much more extended discussion, because there has been some talk of just amending the investor rights.
Yeah, I mean, that's maybe important to clarify. I don't know how much the recent changes in the investment chapter of CETA have been covered here in the media. So what happened in Europe is that because of the huge controversy over ISDS, the Commission is now wrapping the chapter in court language. So they are using terms that people have a lot of trust in: a court, judges, independence, and have redesigned CETA's investment chapter along those lines. I mean, this merits a completely different discussion that could take us many, many hours. But the bottom line is, while there are some procedural changes now, some of them are quite relevant. They're not nothing. For example, the arbitrators that today under most investment treaties can be picked by the parties. So as if you or me, we go to our constitutional court, we could pick 50% of the judges. That's how it works today. This is changed in the CETA. That is relevant. But despite these procedural fixes, or some changes, the overall threat of the investment chapter for taxpayers, for democracy, isn't changed. The investor attacks that we have seen in recent years against environmental legislation, public health decisions, they will all be perfectly possible. The billions of dollars in compensation that we have seen and the skyrocketing claims, they will all be possible. It will be perfectly possible for investors to walk around with this chapter and threaten governments, that want to regulate. So the procedural changes and improvements, they don't really address at all the heart of the problem. But it is true that the whole language of court and the language of reform, and we have fixed the problem, is succeeding to the extent that some people are honestly confused now and think, this is something we can agree on, but we definitely shouldn't.
Thanks. Angela, I've got a similar sort of question. I guess progressives have called for sort of environmental provisions and labor rights provisions to be made a central part of trade agreements. There's been a lot of criticism of side deals that were very limited and ineffective. I guess it's being claimed with the TPP that labor rights is actually entrenched in the heart of the agreement, that it protects labor rights, so there's really nothing for unions to worry about.
Yes, so that's true. That statement has been made both for the labor chapter and the environmental chapter. And so in NAFTA, we had a side agreement, and that was criticized as being too weak. It wasn't enforceable. And in most of Canada's trade agreements, we have labor chapters, but they have no access to the main enforcement. So you can't impose trade sanctions, for example, if a country violates the trade chapter. The United States, since about 2007, has implemented fully enforceable labor rights chapters. And so we can learn from their experience. And what we've seen with the United States, this TPP chapter is based on that United States model. What we can learn is that the labor chapter is very limited in two ways. The first way, it refers to the International Labor Organization's Declaration on the Fundamental Freedoms and Rights at Work. Now that sounds wonderful, it's quite lovely language, but it's basically the preamble. So it's like saying we're all going to agree to the preamble, but we're not all going to agree to the details to enforce the preamble. So for example, workers have the right to associate. That's in this trade agreement. But the convention that lays out what that means exactly, that workers have the right to create their own organizations, that they have the right to come up with laws and constitutions, that they have the right to meet and to do this free from government interference. That detail is all in the convention, and that is not part of this labor agreement. So it's very difficult to bring a case against someone about the right to associate or the right for collective bargaining if you don't refer to those specific details that are in the conventions. So it's limited in that way, and then it's also limited that any violation must be proved to happen in a recurring course of action or inaction in a way that affects trade and investment between the parties. So if Vietnam eliminates its minimum wage, that doesn't necessarily mean we can bring a violation against them. We would have to prove that it in some way affected trade between Canada and Vietnam. And these cases, there's one case ever that has been taken to court. It's between the US and Guatemala, and there are well-known labor violations in Guatemala. And the unions in the United States and Guatemala put this case forward in 2008. It took 7 years before it was even heard, and it's been very ineffective at doing anything to protect workers in Guatemala. So we know that even when it's enforceable, it's so timely and expensive, and the legal bar is so high to prove something, it's very ineffective. So even if it was the best labor chapter, it's not. But even if it were, it's a very weak tool to use to bring up the standards for workers in other countries.
I've got one last question. I guess it has to do with, going back to the TPP mainly, how this is going to play out politically. I guess this is all speculation, but it is striking we're moving to TPP ratification in the US with considerable anti-TPP sentiment on both the Republican and the Democratic side. So it does seem to be politically contested terrain in the US for different purposes. I guess relatedly, this question, I mean, is amending this agreement on the Canadian side is there any mileage in that? I mean, it has to be an up-down vote in the US, so it's hard to know how an amendment process might work, but I don't know. So, I mean, is it just take it or leave it for us? I mean, is this going to be decided in the US anyway? I mean, sorry, that's a lot of questions.
That was a lot of questions.
I'm very puzzled.
And it's easy just to say yes to almost all of what you just said. I think the U.S. is clearly the driver here. I think the government is genuine in the sense that it will consult, whether or not that's just theater, and at the end of the day, this is going to be decided based on whether or not the U.S. decides to move forward with it or not, I think is a pretty fair question. The opposition that we've seen in the United States, I think, leaves the general sense that it's unlikely that things are going to happen. this year anyway. It's possible, of course, during the lame duck session in Congress that they might move forward, but it has become so contentious on both sides that I think certainly many of the people I talk to, even within our own government here, have the sense that this is an issue now for 2017 and that this year does provide a genuine opportunity to consult and perhaps think about whether or not this is something we ought to do or not, and if we do, how we might try to fix it. Now, it's often presented on a take-it-or-leave-it basis. But that said, there is a long history of side letters and other kinds of agreements to try to address some of the sorts of concerns. I mean, we see it in CETA as well, of course, with the ISDS chapter, in which the government was loath to say that they just renegotiated ISDS, but of course that's exactly what they just did. And so the prospect, and it should be noted that the TPP ISDS chapter is much like the old CETA chapter, so when the minister described CETA as the gold standard, notwithstanding the concerns that Pia just referenced, it's hard to understand how they're going to try to sell a TPP chapter that by definition doesn't even meet the Canadian government's own standard for what an ISDS chapter ought to look like. But moving forward, we have a history of trying to reopen and get those kinds of side letters, and notably the United States, it looks like, will be looking to do some of the same kinds of things, as there are any number of issues that they're concerned with. Their concerns don't necessarily mirror ours. Of course, from a Canadian perspective, what they'd like to do is make the deal worse, quite frankly, on a number of issues. But nevertheless, you've got lots of countries that now that they've had the chance to actually take a look at the agreement say, this isn't quite what we would like to see moving forward. And if there's enough of a consensus around that, knowing that you need to have 6 countries that equal 85% of the GDP for this to take effect, perhaps there is an opportunity to make some fixes if the decision is made to move ahead. But I don't see any reason we'd make any sort of decision until we know what the U.S. does.
I had no idea votes were weighted by GDP.
In this instance, it effectively provides the U.S. and Japan with a veto power, unless therein the agreement doesn't take effect.
Ianik, have you got a thought on that?
Je répéterai la même chose.
I would repeat exactly the same thing. I mean, we cannot answer all your questions because we have so little knowledge about the different mechanisms, about the implementation of the treaty, including the one with Europe, the CETA agreement. So we have no data to base ourselves off. So it's difficult for us to oppose these treaties because we don't know what's in it. The way I see it, it will be very difficult to oppose this, either in Canada or in Europe.
Well, it's, I mean, political dynamics are one thing, but to judge, I mean, to go back on what do we think about these agreements, I guess already here in this very short time, it's become clear that the flaws are all over the agreement. I cannot see how such an agreement can be fixed, particularly when you think about, you know, the challenges that we have in our societies. I mean, don't we need agreements that allow us to fight climate change? Social injustice, social inequality. And these agreements, whether it's TPP or TTIP or CETA, are so inadequate for that. And even going further, I mean, they will make some of the solutions to these problems illegal and very expensive. So I really don't see a way of fixing them. For me and for the things I am fighting for, and many people in Europe and I guess also in Canada are fighting for, the only way is to prevent that they ever get ratified.
Last word to you, Angela, and then we'll take some questions from the audience.
Okay, I would just really like to second what Pia said. This agreement is so flawed, and when you compare the TPP to the CETA has all of those flaws in it as well, on healthcare costs, on implementing environmental change, on workers' rights, on using procurement to help grow the economy, to help adjust transition for workers and for the economy. So These are agreements that we've had debates, we've had political debates about elements of these agreements. And for example, on the Temporary Foreign Worker Program, on environmental change, we've had these political debates, and the left has won those debates. But then what we're doing is we're signing the TPP and we're signing the CETA that entrench the losing side of that debate into law. And they kind of go around behind our back and do that. So it's fundamentally anti-democratic, and it's contrary to what we're trying to achieve as a society.
Thank you. So we now have an opportunity to take questions from the floor. There's two volunteers with mics somewhere out there that I can see them.
I see one of them.
We have one question right at the back here, I think. And how long have we got? We've got 20 minutes, so time for a number of questions. If you could keep the questions quite short, though, so
Just
we can take...
Quickly, why would we want to be involved in TPP at all?
Sorry, I didn't hear that.
Why do we want to be involved in the TPP at all? Well, I mean, I'll tell you the response that. So the question for those who couldn't hear, why would we want to be involved in the TPP at all? I mean, the response that comes from those that support it is that as we move towards more and more global supply chains, the need to be in the tent rather than outside of it is one that's important. The other argument that is made is that it opens up some markets that currently have high tariff barriers to Canada. Realistically, the only economy that's really significant is Japan in that regard. From a Canadian perspective, if we exclude the countries that we already have agreements with. I mean, that's the answer that's given, but I think we've had some really compelling reasons why that rationale isn't a good enough one in light of what the agreement actually contains.
Somebody in front here and a gentleman behind afterwards.
Hi. So I work with a global corporate watchdog, some of us, that has millions of members who care a lot about trade. And so what I'm wondering is, what do you think is the next step, the best opportunity to stop this? We've talked about why it's bad, but in the next 6 months, I feel like there's opportunities, and I want to hear your minds talk about that.
So I'm actually on the steering committee of the Trade Justice Network, and we're an organization of unions and community groups, and we're organizing around the hearings that will be coming up. So in Vancouver on April 18th, if you're in Vancouver, there will be a hearing there, consultations with the government, and there will be organized around that public hearings, public discussions. And so as we go across Canada and have these consultations with the government, we're hoping to have these discussions in the public as well. And the Council of Canadians is doing work putting trade on trial the way that they did with the MIA. AI.
Can I just add just to that, just so that you know, even if you're not in Vancouver, you can't attend. The standing committee that is conducting hearings on this has invited people both who would like to appear before the committee, but also people who would simply like to provide their comments to do so. The deadline they've set is the end of this month, the end of April. So if you go to the Standing Committee on International Trade, they've got a page that invites people to provide their views. I should note that the government also has a page. Global Affairs Canada also has a particular email address and an opportunity for input. And I would note that it always helps to talk to your local MP and make sure that they're aware of it, notwithstanding the opportunity to put yourself into the consultation process, but make your elected officials aware of your concerns as well.
And those, when you submit it to either the committee or to the government department, those aren't public. So if you go to Open Media's website, they have a forum where you can submit to the committee. And then they will share your submission publicly as well, so that you have that option if you go through the Open Media website.
There's a gentleman in the middle here. What a question. There was somebody further back, and then Ed. Let's see, put you in your place.
For those presentations. I just wanted to press Pia a little bit more on the discussions around the investment tribunal that's being proposed as a compromise on the investment chapter. It strikes me that this is making things even worse because it will set up a tribunal from which there's no recourse and you can't, appeal to the domestic courts. So it takes the existing system, which is rather ad hoc, of these investment tribunals on an ad hoc basis, and makes it a permanent mechanism. And that seems to me really quite dangerous because it might then spill over into other trade deals. So that's one point. The other point is I would submit that if people have objections to the TPP, the government has, for some reason, considered that CETA is a done deal. But I don't see why people who have objections to the TPP couldn't also object to the CETA because, the same issues, ISDS in particular, prevail in that agreement as well.
Well, on the investment proposal, there is definitely an element of what you allude to in the EU's position, which is directed to the future. So, and you can find that in the CETA. The CETA outlines the vision of establishing a multilateral investment court. So that would be exactly that permanent institution that you mentioned. And what that would mean, it's a World Supreme Court for corporations. Only they can go, and on a basis of rights that go far beyond what they get under any legal system in the world. So that, I agree, is definitely a very, very dangerous perspective and much more dangerous than the existing investment arbitration system we have. What is already in the CETA now is a bit different. They call it a court, but it's not a court. It's also not so permanent. Basically, what CETA does is it establishes a list of 15 people. Don't think of it as a court. It's a list of 15 people. These people will be chosen by the EU and Canada. It's very unclear how that choosing will happen. And then the arbitrators that will decide future investor-state disputes on the basis of CETA can only come from that list. So that is not so much of a difference from existing investor-state proceedings. I really think of it as a list. So it's not so much more permanent. And by the way, because I didn't mention it, if you want to learn more about these changes in the CETA, I invite you to read a publication that we have put together with around 20 NGOs and trade unions in Europe. It's called the Zombie ISDS. Because that's how we call it. You can also call it wolf in sheep's clothing or whatever. We call it the Zombie ISDS, and that publication is online in English and soon also in French.
Ed.
I'd like to ask a related question in terms of the politics of Europe, to get you to speculate about that. I'm sure 99% of the people in this room share your concerns from a democratic point of view about the investment chapter in particular, but not just that. And so when you speculate, you said before that it's not just social democratic parties, some of them have opposed us in Europe, but more conservative parties, elements of the CDU presumably, in Germany. So the question is, what are the real chances on a European-wide basis that this can be defeated on a sort of cross-ideological basis in favor of democracy? And more particularly, what is the likely outcome in Germany? And if Germany goes against it, is it going to go anywhere?
There are chances of stopping CETA in Europe, but they are slim. I want to be honest about that. So the next steps will be that the EU governments will have to vote on CETA, probably in autumn. There are concerns about CETA among EU governments, but it takes a lot for a government to make this a core issue that they fight about, so to go in with a no vote. As you know, we have an economic crisis in Europe. Some of the countries that have concerns, like Greece, they have other things on their agenda that they are fighting for at the moment. So this risk of, the chances of a no vote in the Council are very slim. The second institution that will have to ratify is the European Parliament. There, things look a bit different. But it was for the European Parliament that the European Commission revised CETA, because there were clear signals coming from the European Parliament that the old CETA would not get through the European Parliament. Now we have this whole court PR that is basically made for the Social Democrats in Europe. And we see that some of the MEPs are falling for that PR, and it will be our job to make it very, very difficult for them to ratify CETA. So we could have a no vote in the European Parliament, but it's not around the corner yet. But then there might be another avenue. It is very likely that CETA will also have to be approved by each of the 28 EU member states in their own countries, which mean, for most countries, this will mean that their parliaments will have to vote too. And that will be interesting, because that will mean that one national parliament in one member state and even a regional parliament in some member states can kill CETA in the ratification process. And we are working very, very hard to make this happen. But as you can imagine, I mean, these are 1,600 pages. Been negotiated for years. There's a lot of political and economic capital in this agreement, and a lot of interest also in favor of these agreements, like you have here with the TPP. So it takes a lot of courage and a lot of public pressure for even a regional parliament to say no to CETA. So it is an uphill battle, but we will do all we can to prevent the ratification, because for us it will also mean that resistance against any other trade agreement, such as the TTIP, will be much more difficult in Europe. So CETA is, to some extent, a deal breaker also for us in Europe.
Dan, a comment on Germany specifically?
Sorry?
What's likely to happen in Germany on the issue?
It's really difficult to say. I mean, we have strong resistance in Germany, but we also have strong interests in Germany as an export-oriented country. I mean, our business sector is licking their lips when they see CETA and TTIP. So it's not that all of Germany is opposed. But let's say it will be an interesting battle in Germany, but in other countries as well. Only to mention Austria and also the Netherlands, but also some small Eastern European countries like Slovenia, which is very, very critical of CETA.
Est-ce que nous avons une question en français?
Do we have a question in French? Any questions in French? No? No questions in French?
Having been involved in the MAI a few years ago, France was instrumental in helping us overturn that one. What's France's position on CETA?
So the position of France on CETA is, I would say, France, the French government. The French government is largely in favor of CETA, particularly since the recent changes have been made to the investment chapter. But in France, there is continued and strong resistance, including from judges and from like the legal committee in the Assemblée Nationale. So France will be an interesting country to look at in the ratification battle.
I thought that, sir, it was just behind you. This will be the last question, by the way. We're almost out of time.
My question, now, concerning the observations you made, you spoke against free trade, either in the case of CETA, TETA, or TPP. And based on what I know, if we look at the polls in Canada, it seems that the CETA treaty is favored by Canadians, and even the PTP. I was looking at a poll. It says that 86% of Canadians support the TPP. Only 23% oppose it. Now, it seems to me that despite all these arguments, we cannot seem to show the majority of Canadians that these treaties are bad for us. So what should we do? How can we really change the opinion, the public opinion as well as the opinion among politicians? Well, as Pia said, the problem is that it's never really on the top of the political agenda. It's not a very sexy topic. It's a 6,000-page document. Nobody has read it or understood it except for 3 or 4 weirdos out there. And my grandmother used to say, don't eat food if you don't know what's the list of ingredients. If it has a strange name in the list, don't eat it. And it's the same thing with these treaties. Go ask an MP, what do you understand of these 6,000 pages? Are you ready to eat these 6,000 pages without having any questions? I think, and I was saying it previously, what should be done is to create an alliance between workers, civil society, and mid-sized companies. But we have to work on our elected officials, on MPs in Ottawa. They are the ones who have the power to do something to block this treaty. But I'm certain that the poll you mentioned also applies to our elected officials, and that a good number of them would say, I don't know. And that's the problem. Now, contrary to what we lived with the treaty with the United States, the free trade agreement with the U.S., where we had debates, political and public debates, here nothing is being done because nobody understands what's in that treaty. Now, I don't think any of us here have read the 6,000 pages of the treaty. I did not. I fell asleep reading it. So when you look at the complexity, it's the equivalent of a blank check, and that's a simple message we must communicate with the public and with MPs.
Certainly, it was very informative and interesting panel, so thanks to all of our panelists. I was going to say just a special thanks to Pia for coming so far to be with us. She tells me she's in Canada for a vacation for a while, so we hope you have a wonderful time here, and maybe you'll find some people to put you up on your travels east. Okay, thank you very much.
Merci.